So a lot of you are likely aware, what is it? So healthcare reform, it goes by a lot of different names. ACA, the Affordable Care Act, Obamacare. There's all sorts of different things that people call it, but it's ultimately the law that was enacted back in 2010. So by now, we all know that it was enacted back in 2010. I think it's fair to say that there was a growing number of uninsureds that needed to be addressed. There was change that was needed. If we think back to pre-existing conditions and some other things. And then there was also just some good and some bad in kind of how it was being managed before. So there was certainly change that was needed. So then we've got this major overhaul that happened to the kind of purchasing system of health insurance. And it came with changes. It came with hope, I think a lot of hope. And then also new requirements, which is why I get invited to speak a lot, because there's new requirements often depending on which sector of business that you're in. So if we fast forward, so the law in 2010 was very different than how we interpret and advise today. So if we fast forward even just 1 year, the repeals or the changes to the law started happening in 2011. So in 2011, the free choice voucher was revealed, and also, I don't know if you guys remember, but in the law there was going to be a 1099 required for any vendor of yours that had services of goods for more than $600. So that was going to be a pretty big impact to the distribution of 1099s. So that was repealed, and that was in 2011. And then we jumped to 2012, and that was all over the news. That's when the Supreme Court upheld the individual mandate. So everyone has to have insurance or pay a fine. Not everyone, but most people have to have insurance, and when they file their taxes, they prove that they have that insurance, and therefore they don't pay a tax or a fine into the government. So that was upheld in 2012. In 2013, the Class Act, so you may or may not remember this one, but this was the government's attempt at long-term care built into the healthcare reform law. So that was repealed in 2013. And then in 2014, they repealed the small business deductible cap. So in 2014, they decided that, or they went away with the fact of small employers in that 2 to 50 market having to have a deductible that didn't exceed $2,000 for single or $4,000 for family. For those of you that are managing or aware of health plans in the small business market, we have deductibles in $6,000 to $12,000 ranges. So that would have been a pretty big disruptor in 2014 if there couldn't be a deductible higher in that 2 to 50 market than the 2,000 and 4,000. So we can keep going in 2015. 2015 was a big year. A lot happened in 2015. The PACE Act, that was what allowed small employer, as defined by community rates, stay at 2 to 50. So it was supposed to go to 100. So any employer under 100 was going to be determined as a small employer. And the PACE Act is what allowed that to be at 2 to 50. And it actually gave the states the ability to decide. Auto enrollment was repealed. So for employers that had more than 200 employees, they were going to have to automatically enroll all of their employees into their health plans unless their employee opted out. Okay, so that was repealed, so they didn't have to do that. The Cadillac tax was delayed. And then we also had a delay on some of the other taxes you can see, and they're listed, but also in the employer reporting. And that's important. I'm just mentioning it here because I'm going to touch on something else that happened with that. But there was a delay as it pertains to the employer reporting. You want to ask now? Go ahead.
So for that PACE Act, you said that they gave the opportunity to the states to decide that. Mm-hmm. Are there some states now that have 50 and some use 100?
To my knowledge, they all stayed at 50.
Okay.
Yep, and I'm going to touch on that just a little bit more when we get to that, the employer sizes. So when I was preparing for today, I was thinking what would be valuable, what would be kind of a good, just kind of insight, because you're all in really different positions and how you're integrated into decision making or how you're integrated into as a purchaser. So everyone's in a unique situation, whether it's individual coverage, whether you offer a group health plan or not, whether you're a large employer or a small employer. So I decided to focus on some of the things that we're seeing in the market. Now we're in 2016 that maybe are just good FYIs that we've been kind of catching as time goes on. It doesn't mean that there happening in your, at the municipalities that you're at, or even at the companies that you may work for or be a part of. But I think that it's a good place to start, just to kind of touch base on where things are at. So first one, which I think is probably the most important and that I'm still getting questions on often, and I know it's really tiny writing, so I'm just going to kind of summarize, and you have the slides, but I can answer questions if you want me to, is we're still seeing employers trying to figure out or pull some language to pay employees a specified dollar amount, regardless of its pre or post-tax, to purchase an individual plan and not offer that group plan. So employer payment plans is the piece that this number one mistake is addressing. And in 2000, I believe it was 2013, they made it very clear that there was a combined effort to just explain that that's not compliant and that they don't want, and I get the question a lot as to why. Why would the government or why would the law not want employers to be able to just give a specified dollar amount, especially if it's not on a pre-tax basis? And ultimately, I think the objection is the double dipping. So if they can go to the marketplace and get a subsidy based on their income, they're getting subsidized from the government to go purchase that individual plan. They didn't also want that subsidy to be coming from an employer as well. So they want the employer to have an underlying group health plan in the event that they're going to be in that benefits arena. Okay, so we still get this a lot, and this was, over the last couple of years, a really hot topic item in different municipalities that we've talked to. So certainly something that we still see. Do you have a question? Okay, yeah.
So if they just include it as part of their wage,
Mm-hmm.
how are they supposed to,
Yep.
how does the IRS or anybody prove or disprove that?
That's the argument in the language, too, in your slide, that is the only way you could do it, is if it was just part of the compensation but not specifically allocated to saying that you have to use that for health care, or there's not a policy in your handbook that says we increased your wage by X because we're not giving you health care. So if it's just part of standard compensation and you're able to attract and retain with that method, I think that is what most small employers have been doing or did after they realized they couldn't have a specified allocation. Good question. So what do we see on the horizon for this? So I've been talking a lot small, large, and there's a lot of different language I'm going to get into in regards to who's applicable large employer, who's got community rates. But really, when I'm talking 2 to 50, when I say small group, there is a bill that is very actually popular right now, but unfortunately probably only has a 0 to 3% chance of passing because it's an election year. But there's bipartisan support to bring back a standalone HRA. For lack of using too much insurance jargon, I'll explain what that is. But the ability for an employer to set aside dollars and allocate those for benefits is what ACA kind of took away, and the goal is to maybe bring that back for that 2 to 50 employer market. So if they do, that will have a substantial impact, I think, on just the landscape of that 2 to 50 employer market, on whether or not they still want to be in the business of offering coverage. And so obviously employers are going to have to sit back and think attraction, retention, morale. There's a lot of different things that are going into these discussions. But in the event that this passes maybe in 2017, that could really change the landscape for that 2 to 50 market, and it would bring back the ability for employers to actually set it aside and treat it as a benefit versus just putting it into wages and not being able to identify that as being medical. Yeah?
Jill, would that mean that they still have to have a group plan for the employer?
Not if this passes. So that's the trick right now, is that you have to have a group health plan in order to have a health reimbursement account. And
In theory, you could have, instead of having your group plan for your employers or employees, you could take and say, all right, we're going to put X number of dollars in this, and then you go get your own plan.
yes. Yes. And I have no crystal ball, but just based on what we're hearing and what the speakers in the industry that I'm going to, it's very popular. They want to be able to bring that back for the small employer, or that 2 to 50 market. It's just a matter of what it's going to get attached to and what's going to actually pass in the next 12 to 24 months. So we're watching that, but let's chat a little bit more. Before I'm going to touch on that because I think you bring up a good point. So the underlying group health plan wouldn't be necessary, but the way that this is written, you wouldn't be able to have one. So that's going to be a big differentiator on groups that decide to do it versus don't. So you can't do that piece of it where you're allocating dollars and offer a group health plan. It's going to be kind of an either-or situation that employers are going to be faced with. The other thing you can't do is you can't have, if it passes exactly the way it's written now, you won't be able to have different amounts for different individuals. So we have municipalities that have group health plans that maybe if they've got different hours for different classifications, they might be paying different amounts for different people. This, if it passes the way it is today, would require that it's only employer money. So in a lot of cases right now, a health plan is some employee dollars, some employer dollars for the premium. It can only be employer money. You have to give the same amount to everyone. You cannot offer a group health plan. And then the fourth thing is you obviously would need proof of payment. So you would have some type of vendor typically that you would be submitting claims to get that reimbursement, which again, this is something that we used to see 7 years ago, and then 6 years, and then 5 years, and then they just kept clarifying that you can't do that, and so now we don't see them at all anymore, but they could easily come back, and if they do, it'll be interesting to see what that does to the landscape. We're only on mistake number 1. All right, mistake number 2. So this one, all employers are required to offer health insurance. The reason why I bring this one in, majority of the attendees here today are in that under 50 market, so in that case, you're likely aware that you're not required to offer, but we still get a lot of questions coming in on just, well, don't they have to offer me coverage? We'll get it from an employee who maybe works for an employer that has 35 employees. Well, that employer is not an applicable large employer, therefore they're not required to offer coverage. So just a good thing to keep in mind is that not every employer is required at this point to either pay or play, which I'll get into, but every employer has the choice of offering coverage, and so we get these questions quite a bit. So who's a small employer? So within the PACE, that's what we were talking about, and that's when I mentioned I was going to dig into this a little bit more. PACE Act gave the authority to each state to decide if they were going to continue to have that be small employers be 50 and under, or if they were going to extend that to 100 or lower. So for any of you that are in municipalities between 50 and 99, this was a really big ticket item. So in that 50 to 99 space, those employers had been experience rated. They weren't on what's called community rates. So for those of you that have small employer plans, you're probably familiar with what community rates are. They're published, they're processed through the carriers, agreed upon at some level with the state, and then they're published, and then we pull those, and that's the rates that are available in that 2 to 50 space. They're based on age, and they're based on your location. Typically, those are the two categories that create what the rate is. So in that 50 to 99 market, they weren't on those community rates, and last fall, all of those groups that were in that 50 to 99 space were slotted to go on to those plans, those community rates. And last fall, the PACE Act decided that each state got to pick that, and so then each state then took the liberty, and to your question, they stayed at 50. So the small market, as we know it, is not changing. It's going to be in that 2 to 50 space. So those are the employers that are subject to what's called community rating, and they're not rated based on the experience of their population, which they used to be prior to ACA. Okay? So then the other thing I'm just going to touch on with Wisconsin. So I think everyone in here is a Wisconsin municipality. This is something that wasn't the same across state lines. So when everyone's heard of grandfathering, and now we have grandmothering or transitional plans or zombie plans. They go by a lot of different names, but in February of this year, the state of Wisconsin is allowing or extending the ability for some groups in that 2 to 50 market that had a really good health population, they had good risk, they had good rates. They've been kind of holding on to these older plans, for lack of a better term. They haven't moved to the community rates yet because they were given the opportunity to renew on the same plan with the same carrier as long as they wanted to until this expired. And then in February of this year, it was just extended till the end of next year. So I look at it kind of in buckets, and sometimes that makes it a little bit easier to understand. So you've got it, the individual market is one bucket or risk pool. Then you've got your 2 to 50 market. That's another risk pool or bucket, and that's the community rates. Then you've got 50 plus employers that are considered large employers, and they're underwritten. They're rated based on the risk of their group. They've got more options with plan designs, et cetera. And then in Wisconsin, unlike your neighbor in Minnesota, we have what are called transitional plans. And those are the plans that in the 2 to 50 space, it's like a subset bucket of groups that haven't gotten rid of their old plans yet. Okay? So typically the only people that are still going to be on transitional plans are groups that have experienced pretty good risk over the years. So their rate every year is still better than the community rate. So as long as their rates continue to be better than the community rate, they're going to avoid going to those community rates as long as they can. And that expires at the end of next year. So there are still some groups that are on those plans as well. It's a lot to take in, right? We're not even halfway done. So it's going to get easier. The next three mistakes that I'm just going to touch on. Common ownership. This isn't something that I'm going to go in depth on this, but this comes up almost every time we talk to even sometimes in-force clients, and it has a lot to do with the controlled group. The IRS has controlled group rules, and so a lot of employers haven't necessarily connected certain common ownership issues and counting all the employees across everything they own. And so oftentimes it's whether or not they've talked to their accountant about that, or if they've done some of the just listing out of all the things that they may be involved in. A lot of times that can create them into being an applicable large employer versus being a small employer thinking, well, it's just this company. So if you're just looking at one company, they might only have 40 people. They're not a large employer. But then when you take into account that they may have common ownership or controlled group in other companies, that's when it can start getting pretty integrated. So that's just something that we find a lot and we're talking a lot about right now. Number 4 is non-discrimination rules. And I bring this one up because if you remember back to Tom's question too about those HRAs and what they would allow, you have, the way it's written today, you would have to give the same amount to each employee. The non-discrimination rules were written into the law, but in 2012 they were delayed or they weren't going in force until further guidance. So we've been waiting for the non-discrimination rules guidance since I think December of 2012. And we still get asked about this almost every year because if and when they release the non-discrimination rules, it's going to impact a lot of employers' plans and how they're structuring their contributions today. And what I mean by that, so if you're self-insured, you already have non-discrimination rules that you're abiding by. So there isn't as much of a concern with these coming out because you're already going through that process. But for fully insured plans, you can have basically a classification and treat different employees differently based on certain criteria, whether it's ownership or hours worked. There's all different ways that people have kind of developed their structures. And in the event that the non-discrimination rules come out or get passed, they might change in the way that they're currently written or were written. But that's another big one that we get questions on where people don't think that they have the ability to have different structures around contributions and things like that. So as of today, you can still do that. And that's just something that we watch and get a lot of questions on. And then the last one that I wanted to bring up was only employers, large employers, have to comply with reporting requirements. So this is a big one because in a normal situation, a blanket statement, if you have 50 or more full-time equivalents, you're an applicable large employer. And if you're an applicable large employer, you are subject to the ACA reporting requirements, tracking and reporting. However, what gets missed, and the reason this is on this slide, is that there's some new developing products and kind of innovative plan designs that are on a self-funded platform in that small business market. They're not true self-funded plans like what would be traditional in nature, but we're starting to see them a lot and actually have clients that are on them. And those, once you move to that type of platform, you're required to report because that self-insurance piece makes you required to report. So we have groups of 15 that are subject to the ACA tracking and reporting because of the product that they're on. So it's not just the 50 or more full-time equivalents. It could also be the type of product. In most cases, if you have less than 50 FTEs and you're on a fully insured plan, you don't have to report. And because I know most of us in the room aren't, the next 3 slides we get to go through really fast. So tracking and reporting. This we get a lot of questions on, even for employers that aren't subject to the reporting. And the reason I bring it up is simply that we get employees calling and asking questions about documents they've gotten from insurance carriers. So there's 1050, 6055, and 6056. And one of the documents that an employee would get is going to help them go to file their taxes and prove that they had coverage. So that's one of the I guess, line items for reporting. And then the 56 is the employer saying whether or not they offered affordable, credible coverage. So only employers that have 50 or more full-time equivalents are subject to the employer mandate. And the employer mandate says that you either pay or play, right? So that's where a lot of the discussion around healthcare reform lands. And because there's not a lot of employers in the room today that are subject to that, I'm not going to dive really deep into it, but I'm happy to answer a lot of questions if you have them. So an employer in that over 50 full-time equivalent market has some decisions to make. And in the municipal market and in public sector, we typically don't see a lot of concerns when it comes to offering affordable, credible coverage. It's usually a non-issue, but to know how the rule works, Test 1 is minimum value. So the first test or the first penalty is whether or not you offer a plan that meets an actuarial value of 60% or greater. And then Test 2 is the affordability piece. And the affordability is a little bit more complicated and actually becomes more of penalty management for employers that aren't meeting the affordability thresholds, because you get subject to that second penalty if an employee their coverage isn't deemed affordable and they go and get a subsidy on the exchange, okay? So it's not just a blanket penalty. So the penalties can, just because of the room and the audience, like I said, I can certainly answer questions, but the penalties are increasing. And so there was a little bit of transition relief for that 50 to 99 market. So the penalty for an employer that had 75 employees isn't necessarily subject to that in 2015 because they have some transition relief. They still had to report. They still had to give the information to the government, but they wouldn't have to pay a penalty if they weren't offering affordable, credible coverage last year. This year they will. So in 2016, it applies to all employers that have 50 or more full-time equivalents. So let's take a minute before we turn and kind of switch gears a little bit and do the math, because we get this question a lot too. So we have some local data. So if you just take the numbers on the slide, and we just did really easy math, $3,240, right, for a year for an employee in 2016. So that's $270 a month. As you guys can imagine, there's not a lot of employers that are paying less than $270 a month in premium, right? A lot of employers are paying more than that. So the exchange, going to the marketplace and getting a subsidy, triggers that affordability penalty. So that's where you could see the risk. There could be some risk there if you weren't offering an affordable, credible plan. So in Western Wisconsin, the average single premium that we had this year based on the data that we collected was $5,940. Okay, that's the average single premium. Obviously different plan designs, all different size employers, but that was Western Wisconsin's number. An employer of all different industry combined, the average contribution was 77% for single. Okay, so if we take that, we're at about $4,500 a year, which is more than the penalty, right? So if you're just looking at average numbers in Western Wisconsin, so that leaves all the employers in that 50-plus market, you know, working with their broker or their consultant and figuring out what makes sense and what do the benefits mean to our employees, how is that going to impact morale, what does that mean for attraction and retention in the future if we do or don't offer a plan. So there's a lot going on in that 50-plus space as to what do we want to do, what does that look like, okay? Okay, so let's bring it back up a little bit. So one, you could argue it's really unaffordable either way, right? And that's what's all over the news. If you look at paying a penalty, if you look at paying the premiums are going up. So I just want to talk kind of about what is, regardless of what size of an employer you are, what do people need to kind of be thinking about? I would say watching for scams would be my biggest takeaway at this moment. So employers are starting to get these notices, HHS, marketplace notice. What this means is that an employee went to the marketplace. So in the state of Wisconsin, we have the Federal Exchange, and they purchased an individual policy and they got a subsidy, okay? In that process, they listed you as an employer. So by listing you as an employer, this is just a cross-check or a checks and balance to say, hey employer, hey Joan, you have an employee that went to the marketplace and said that you didn't offer him affordable, credible coverage. And Joan may say, well, that's okay. We're under 50, we don't have to offer, we don't have to pay or play, and so be it. Or maybe that person worked for me for 1 month, they weren't even eligible, has nothing to do with you, that's fine. But my number one takeaway is at least read the letter, because they're not all the same. Some of them give you 90 days to respond. And some of them you may want to respond to, some of them you may not. It just depends on the situation. I can't blanket statement say don't disregard them or say react to every single one. It just depends on the situation. Scams are coming with emails that appear to be from the IRS. So we've been starting to see employers pushing those to us to say, hey, would I be getting my penalty notification saying I need to like send my banking information electronically? You know, obviously there's all these signs that say don't do that, but it's, I think, just the tipping point of what we're gonna see, as this is another avenue where employers are potentially gonna have fines and they're going to need to pay in for those, and no one understands exactly what that's gonna look like yet. So that's why if they can get in early with their scams, they might be able to take advantage of a couple people. So I would highly recommend auditing or cross-checking or letting somebody else look at any type of email that might come through that has to do with these penalties or healthcare reform. This is my slide that I wanted to talk about that's wrong as of yesterday. So it's a fast and ferocious changing market. The FSA, the health FSA on the second or the first bullet underneath the grid, actually jumped to 2,600 as of yesterday for 2017. So we just got that notification. Not much I want to dive into on this slide. I just want to let you know that the amounts and the levels that are compliant are changing. So for example, if you look at your HSAs and what's allowed to go into a health savings account, that's getting tweaked. So work with, you can Google it, but you can also work with somebody just to know exactly where those levels are and make sure that your deductibles are set appropriately if you do have an HSA plan or if you have an embedded deductible. In 2018, for anybody who's interested, the out-of-pocket maximum, the level that it can be at in 2018 is $7,350 for single or $14,700 for families. So the question becomes, regardless of what kind of shakes out and all the changes over the next few years, is those numbers are extremely high when you consider what an employee could potentially be faced with on a major medical plan that meets the affordability and the credibility rules as what's deemed affordable. So you've got $7,350 a year that you potentially could put on as your out-of-pocket maximum in 2018. So those continue to tick up. Another one, if you are offering a group health plan, just note that your plan renewal after April of next year has a different summary of benefits and coverage. It's an updated summary of benefits and coverage. So your renewals throughout this fall and potentially early of 2017 won't be impacted. It'll be your renewal the following year. And the biggest difference is that there's a new example of a broken foot. So there's, if you guys know what I'm talking about on the SBCs, you've got your maternity and your managing type 2 diabetes as two examples on the back of a document that you have to give everyone. If you have a health plan, there's going to be a third example. Okay, Cadillac tax. I put a Bentley emblem. I'm not sure Cadillac covers it anymore. Bipartisan support to repeal this. It's a big ticket item as it pertains to how much it was going to or is going to bring in from a funding perspective for the law. So that's why there's some controversy over whether it'll actually get repealed. It was delayed to 2020. So the question, or the point, I guess, for the takeaway here is if you're doing collective bargaining agreements, note that sometimes they go out for quite a few years, and so this is just going to be on the radar. It doesn't necessarily need to be on the front burner. Like I said, I personally think we could see this go away. But as you do the agreements, and if you, depending on where the municipality's plans are, if they're making HSA contributions, if the employees have FSA, et cetera, those all get calculated into whether or not you're meeting or exceeding those thresholds. So the CBO estimated almost $150 billion would come in from this specific Cadillac tax. And that was when it was 2018 to 2025. Well, if you take a step back, and now we've got just from 2020 to 2025, they dropped that number down to 80 billion, but that's still a big dollar amount that will need to get somehow funded in a different way if they decide to repeal this piece of it. And another interesting piece of this is only 1/4 of those dollars were going to be coming from the tax itself, that 40% excise tax that you would have to pay in. The other 3/4 of that estimate was based on cost shifting. So employers either shifting away to having employees have more taxable income, so the payroll tax is on that, or lowering their plans and not having as much of a tax deduction on their portions that they're paying. So interesting fact, but we'll watch that one. So these are two quick cases that I think will be fun. If you're me, I say fun, but everyone else, maybe not fun. There's two. One is whether or not, so the House of Representatives versus Burwell, the last we got something on this was in September, and it was a congressional research addressing whether or not Congress can sue. And basically what this is saying is, was it legal for the IRS to delay the employer reporting requirements? So that's what's being involved in this. And our ERISA attorneys, don't necessarily have an opinion one way or the other, but they do state that if they say yes, that could implicate a lot of other cases historically or in the future. So that one will be interesting in our worlds, maybe not anyone else's. And then the other one is Dave & Buster's, which you maybe read about probably about a year ago. We haven't heard anything on this since February of 2016. This was a situation where an employer, there's a class action lawsuit involving about 10,000 employees right now, and they're stating that their hours were involuntarily reduced and that it violated ERISA. So in 2016, in February, they denied the motion to dismiss that, but that doesn't necessarily mean that it's going to go through. But basically what happened, an assistant manager and a manager in the Times Square location of Dave & Buster's announced to the employees that they were going to be reducing hours or cutting shifts or changing scheduling because the impact of not doing that could potentially be upwards of $2 million to the company due to healthcare reform. And that was enough evidence for this to become now a class action lawsuit. So biggest takeaway is, depending on what type of communication and how involved all of the employees are in all the discussions, it's certainly something to be thinking about. Think before you communicate and know what exactly the implications are of what you decide to do. So no one really wants to talk about politics anymore, including me, so it's going to be really quick, because I could probably go on for a long time. But does everybody know who this is? Paul Ryan, right? So surprisingly enough, it's not communicated as much, but what we hear is that he's actually pretty well respected from both Republicans and Democrats. He's known, I think, or we're told, for kind of getting into the weeds and really digging into different things. And I just want to level set on, regardless of who gets elected, there's a lot of other players, I guess, that have opinions or have had plans. And so I don't necessarily think one way versus the other, and when it comes to the presidential election, is going to tell us what we're going to see for healthcare changes in the future. But I just wanted to note, his idea is that everyone would own their own individual policy. So whether you're for that or against that, it's a very interesting approach. And then there would be a tax credit, so individuals could go use their tax credits and get individual plans, and it would be eliminating that employer-sponsored platform. So one take, right? There's also another plan, not necessarily by him, that talks about capping how much employers can deduct. So would that change the landscape? Absolutely. If employers can only deduct to a certain level, would they adjust how they're giving their plans out? So lots of different plans out there. Trump and Hillary, they're all over the news, and now even more because the average increase in the individual market's about 25%. 50% in Minnesota for MNsure was the average increase for individuals over there. Those aren't just kind of numbers pulled out. Those are real numbers. We have people calling our office. They're literally getting 50% increases on their individual health insurance at our neighbors. Here, certain areas, St. Croix County, not getting hit nearly as bad. But the average, they can say 25% because it's taking all the states that went with the federal exchange, not the ones that did their own individual exchanges like Minnesota did. Okay? Trump, repeal and replace. He says it a lot. I think it's really hard to imagine repealing especially some of the favorable things like no pre-existing conditions. People really like that. Some people really like the fact that dependents can stay on until they're 26. Some don't. But ultimately, there are certain things that were in the law that to just repeal it, I think, is not likely. But that's the campaign on the Trump side. Clinton, after some of these announcements with the increases, has admitted to some fixing and some needs there, not necessarily how. And the other thing that Clinton is pretty adamant about is lowering those out-of-pocket costs, and I talked about those as we went along. She got a lot of what I think she had initially wanted on the healthcare reform side in the initial bill, but that doesn't necessarily mean that there isn't more in that play. And then neither are really talking about single payer, because that was Bernie's thing, single payer plan, right? What is single payer? Well, it became kind of a household name, and really it's one system. So whether that's federal government running healthcare. I'm trying very hard to just refrain from opinion because I think that there's a million things you could talk about in any of the approaches. But I think, again, the nutshell in all of this is that change is probably, I think, inevitable. You could say likely if you don't think inevitable is fair. I would watch Colorado. If this stuff fires you up as much as it fires me up, Colorado is going to be really fun. They have on the ballot that state care, so Colorado Care. It's the entire state of Colorado. They're going to vote yes or no on November 8th, and it's a 3.3% on employee tax, and this is all wages, tips, everything, and then a 6.66 or whatever the difference is on the employer, equating to a 10% tax. So they would eliminate health plans. There would be Colorado's care system. They would partner. There would be some out-of-state coverage. It would be given to all residents in Colorado, and they're voting on that this year. So if they vote yes, and I have websites and resources galore, if people are really into it, I can share them. It'll be very interesting if it passes. Some say it'll probably not pass, and it'll go into needing more information and kind of, there's a lot more to it than what I'm sharing here just because of the time. But regardless of what happens, I think there's other things on the horizon, whether it's single payer, whether it's kind of watching what other states do. Prescriptions are a really big topic right now, and I think in the large employer market, that's one of the things that's getting the most kind of concern or addressed. Great new innovative drugs. I think we're in a new era for prescriptions, but they come at a cost, and the cost for prescriptions have now reached about 25% of like an employer's spend, which is a lot higher than it used to be. So I think watching the drugs and prescription developments is going to be an important factor as we continue to try to control costs. The medical carrier market has also changed, and that's another factor that's kind of playing into what happens next. Narrowing networks, provider networks, you've heard this a lot in the individual market. So if you have employees that are trying to find a health plan, they might only have one option, depending on what county you're in, and that option may or may not include Mayo, as an example. So there's certain things that are happening on the carrier market, and provider systems that can add efficiencies, but it can also limit choice. So it's not necessarily good or bad, but it's changing, it's shifting. There's also July of 17, there's going to be an announcement on whether or not the two acquisitions that were huge and all over the news. Aetna was going to acquire Humana, that was huge, and then Anthem was going to acquire Cigna. That's another two really big provider systems in those, and they got stopped. And we're expecting to hear if they're going to let those go through in July of next year. So we'll have our new president. And so there's just a lot, right? A lot going on. So what are people doing about it? So I have like one slide on that. So the one thing I want to point out in the individual market, what we're seeing, employee employees or individuals that have good health risk and don't necessarily feel like they want to pay a 50% more premium, they're going uninsured. So they're taking the penalty, they're looking at their income, and then they're looking at their premium, and they're saying, well, I'm going to roll the dice because worst case scenario, they have short-term medical plans. They're 3 months. You can buy one. It's typically catastrophic. It's not going to avoid the penalty, but it would get you 3 months of coverage, and you might have a high deductible, but that's better than what the alternative of not having coverage maybe at all. And then in January, there's open enrollment and no pre-existing conditions. So if I get diagnosed with something, I can just go on and get a plan then. So that's one thing that we're seeing in the individual market. And then in the small group market, I talked about the community rates. What we're seeing there is in Wisconsin, not as much as in Minnesota, because we still have those transitional plans that I talked about. But groups that have healthier risk are looking at these level funded or self-insured products. The product itself doesn't have as much risk as a true self-insured arrangement does. But the reason for this slide is to say, okay, if all the healthier risks, so those are the two examples I gave you were the healthier risk, and they're staying out of the risk pools, right? They're not going into the individual risk pool to help offset the ones that are using the insurance, and they're not going into the small group risk pool because they're either on their transitional plan or they're looking at some unique funding and opportunities. So what's left then is the higher risk, which obviously then the rates continue to grow. So this came out in June from Kaiser on whether or not HHS is going to put a halt to short-term medical plans. So that would obviously change the landscape a little bit because that is one way that an individual could get some coverage if they went uninsured. The question is, will this trickle down then into level funding or self-funding arrangements that small employers are doing? So we're watching all that. There's no doubt that the small employer market has an impact, a significant impact with healthcare reform, but you know, it used to be cost shifting. When I would say, what are employers doing? They cost shift. Well, now I think it's more of thinking outside the box, thinking innovatively, thinking about what's going on around the state. What are other employers doing? There's consortiums for municipalities that have started. There's captives that municipalities have reviewed and are looking at. There's all sorts of engagement tools. There's transparency tools, a lot of different ways to get the employees engaged in the process to really help control the cost versus just talking premium and actually talking the coverage and the provider network and that type of thing. So that's what we're seeing, and that's where we're kind of aiming, if you will, as to what's next. Again, with our eye on kind of the political side, because that's going to shift what employers can and can't do. And I already knew it was too much, so I put the slide in for you. But I really didn't know where to stop because I could just keep going and going and going. So hopefully, I mean, I wanted to give you a little bit of all the different aspects, but at the end of the day, I mean, we have different market segments with experts. Like we have somebody who just does individual and somebody who just does small group. So it allows us to be experts in those arenas. So I would say if you still have questions, just call us. Obviously, we don't have, you know, there's no obligation to do anything but ask your question. We're happy to help. So hopefully I just incited a little bit.
Quick question, the 50 full-time equivalent for 2016, that's based on 2015 numbers, isn't it? And it'll be the same going forward, like 17 is based on 16.
Yeah, because you have to use the data that you have. Yep, exactly. Yep, so you're always going to be looking a year back. Same with reporting. So that was another big one. You know, in 2015, you were reporting on 2014 data. So it's always going to be that year behind. So there are situations where we have employers that are clearly over 50 right now, but when they did all their math last year, they didn't have to do the reporting. Yep, great question.